Could I welcome our witnesses to the committee? Thank you for coming along this afternoon. In a moment, I'm just going to ask you just to introduce yourselves, to say who you are and who you represent. Could I remind the committee that this session is due to end at 4:30. We're still on amber alert for a division in the main chamber. Should a division be called at 4:15 or after, I will invite the whip to move that the committee be adjourned. And if we could start right to left with Catherine Hopkins.
Good afternoon, I'm Catherine Hopkins. I'm Legal Director at AvMA, which is Action Against Medical Accidents, a UK-wide charity that campaigns for patient safety and justice.
Thank you.
I'm Mirish Lyons. I'm the immediate past president of APL, which is the Association of Personal Injury Lawyers. We're an organisation of around 5,000 lawyers who act for those who are injured through no fault of their own. We're a not-for-profit organisation.
Thank you.
My name is Nick Starling. I'm Director of General Insurance and Health at the Association of British Insurers, which represents the interests of the UK insurance industry.
Thank you. Yvonne Pavard.
Ask Catherine, what sort of injuries do you deal with through AvMA?
We only deal with people who are injured in the course of healthcare, and that could be anything in a healthcare setting. We have a helpline which is open to the general public, and injuries can be any sort, from self-limiting injuries where a surgery has gone wrong and somebody has made a recovery within a few months, to perhaps birth injury of a child where they face a lifetime of severe disability.
And what percentage would you say of people who come are children? And what percentage would you say, if these reforms go through, of those would not be able to be dealt with?
Catherine Hopkins.
We are extremely concerned about the effect of the loss of clinical negligence from scope, particularly for children, and I would also say people with serious and persisting injury. We don't see conditional fee agreements as a viable alternative, despite what is often being repeated. We don't see them as particularly viable now under the present rules, but more so in the future.
Thank you.
Tom Brake.
Just a slightly different aspect of clinical negligence. What would be your view about the impact of a statutory duty of candour in terms of professional staff reporting an accident, a medical accident? What would be your view about the potential for that to cut down on litigation?
It's possible that it will cut down on litigation in some circumstances. People feel they do have a duty, and it's quite right that they do, to know what's gone wrong in hospital. Occasionally people do bring claims, civil claims, to find out what's wrong, but you couldn't bring one just to find out what's wrong. People will only bring a civil claim if they've got damage, physical damage, psychological damage, which is compensatable through the civil court system. I think it's very unlikely that anyone would bring a claim to find out what went wrong, because there isn't a remedy there simply to get disclosure. I don't think that will have a huge impact, although it's highly desirable.
Andy Slaughter, then Dave Watts.
Can I start by asking, we're talking about CFAs, what sort of people bring CFAs? What's the typical CFA case?
So is that to me?
Yeah, well, you can start.
Well, I think almost anybody can use a CFA to bring a case, and that's one of the real merits of the regime as it currently stands. It provides access to justice for literally everybody. But the key is that it provides access to justice for those who wouldn't be able to afford to bring a claim in any other way. And particularly in the field of personal injury and clinical negligence, where people are not eligible for legal aid, it really is the only route to access to justice, unless they happen to have the benefit of before the event legal expense insurance.
I mean, do you have any figures? I mean, if you don't have them here, you can write us by all means in terms of what. Part of the reason I ask is that you hear about people who can afford to bring litigation in their name using CFAs because they find it convenient for some reason. What I'd be interested in is what the typical, what the income, what the background is of a CFA.
Well, I mean, there are
Your
obviously
clients.
noted cases, Naomi Campbell, for example, on the front page of the newspapers, but that really is the exception. By and large, no-win, no-fee agreements, conditional fee agreements are used by ordinary people who would not otherwise be able to afford to obtain any redress or compensation. I'm a clinical negligence practitioner in practice myself, and for those clients of ours who aren't eligible for legal aid, almost all of the cases are run under a no-win, no-fee basis, and our real concern is that the current proposals are a double whammy for those clients, because not only will they no longer be able to access, for those who are eligible for legal aid, they'll have no access to legal aid. For those who would otherwise bring a case through a no-win, no-fee agreement will now face having to pay up to a quarter of their compensation in legal costs, and that just seems fundamentally unfair and wrong.
May I make an observation here?
Thanks, darling.
I can't make a great observation on the sort of people who bring CFAs at the moment, except to say that our member companies deal with people who have been injured or made ill through no fault of their own. And I want to make this fundamental point here, that we fundamentally agree that in any system it's important that people who have been in that situation, in a car accident, a workplace accident, it's not their fault, they have an injury, it is essential that they get quick, speedy and proper redress, and that is fundamental to the approach that we take. That can be through the legal system, it can be outside the legal system, but it is fundamental to the approach we take. And we believe that the package of reforms that Jackson's put forward, some of which are under scrutiny with this bill, are going to improve and enhance that system, reduce its cost, increase its speed and increase its effectiveness.
I think, as an organisation, we strongly disagree with that position, because we see that any litigant who is going to have to bring a claim financed by a conditional fee agreement will be worse off than they are now. There are two extremes. One is the brain-injured child. The less than 10% of the damages awarded to a child, even when the damages are in millions of pounds, represent pain, suffering and loss of amenity. Most of the damages represent losses consequent on that child's injury. And yet those in themselves are not always enough to cover the costs. In our submission to the consultation process on the Jackson reforms, we provided case studies which showed that the general damages element, pain, suffering, loss of amenity, are needed for these children to supplement their accommodation costs. Without that, their damages will not pay for the adapted accommodation they require. And the past losses are not that child's in any event. They are usually owed in trust to that child's parents, who might have spent 5, 10 or 15 years providing free care for the child. And although most parents are very generous and don't immediately say which bit of this damages is mine, it's not the child's, and yet both the general damages and the past losses are available up to 25%, up to the cap of 25% for a deduction. And we believe that that will leave a severely disabled child in a worse position, much worse than they are currently. Further, if you look at the sort of squeezed middle of our society, the people that Mirish has just talked about, people on average incomes, 30, 40, 50,000 pounds, you wouldn't be able to afford to bring a claim without a conditional fee agreement, and you wouldn't be eligible for legal aid. And if you say your damages because your injury is self-limiting, so you're recovered in 2 or 3 years, but lost a significant amount of your income, 25% of your damages could be taken, or that's all of them if you don't have future damages, towards a success fee. And if a chunk of those, take say a self-employed plumber, a chunk of the damages will be his loss of earnings, and he'll never get those back because they'll be deducted from the conditional fee agreement, under the arrangements of the conditional fee agreement. So people will be left seriously at a disadvantage.
Yes, okay, sorry. Sorry.
I was going to say there's a broader point, which is that the whole premise behind the package of reforms that this part of the bill is concerned with are to address the issue of disproportionate costs, all stemming from Lord Justice Jackson's report on this. But of course, as you'll all be aware, the Ministry of Justice has been overseeing a very successful pilot that's been introduced for road traffic claims up to £10,000, which has fixed costs for those cases, £1,350 plus a 12.5% uplift. So up to 75% of all personal injury claims are now in a streamlined, fast-track, fixed-cost process. That's addressed the issue of disproportionate costs in 3/4 of all personal injury cases. What we are now left with, and I should add that I know the Ministry are currently consulting on extending that scheme to cover other personal injury cases that may take it as high as 90 to 95% of all personal injury cases. What we're left with are the really difficult, complicated cases, industrial disease, clinical negligence. Those are the sort of catastrophic injury. Those are the sort of cases where clients are going to find it very, very difficult to find a lawyer to take expensive, difficult litigation on his behalf. And they're going to find it very difficult if they lose those cases. And they're going to find it very difficult in the absence of legal aid to bring those cases where legal aid will otherwise be available.
May I add an observation to that?
Nick Starling.
I want to distinguish here between sort of catastrophic injury claims and the more straightforward ones. Clearly, our members are less involved in clinical cases, but they obviously do deal with massive motor claims, catastrophic claims there, and it's absolutely essential that people are compensated according to what their needs are, and that's vital. That needs to happen. And I'd merely make the observation that the 25% limit is not a target; it is just an absolute maximum that lawyers can take, and that need necessarily be taken. If we look at the vast majority of straightforward claims, I think that's where the problems lie in the system. They attract disproportionate costs. We now have an extremely simple motor portal system which requires very little input. Liability is usually very easily determined. As Mrs. Lyons has just pointed out, the fee for that, which is $1,350, it's $1,200 plus VAT, is utterly disproportionate to what needs to happen. So we think a fundamental part of cleaning up the system is a substantial reduction in those fixed fee costs. Now, I know that's not in the bill, but that's an important part of the whole system of reform. And if you did reduce these fixed fee costs, of course, the problem of referral fees, which we'd also like to see banned, goes away, because it wouldn't be worth people's while to pay a large sum of money to get an even larger sum of money in costs.
I can see why you might think some of the President Bill Starling are helpful to your members or favourable to them, but you actually said that they were better for claimants as well, if I understood you correctly. And we've heard from the other two panel members about the 25% or up to 25%. That may be taken from meritorious claimants' damages. I appreciate your point on clinical negligence. It's not what you principally deal with, but I noted that the submission on legal aid, this in fact, by the NHS LA, they said, we've serious concerns over the proposal to withdraw legal aid from clinical negligence claims. We question whether CFAs are likely really available to fund many of the more serious claims currently brought via legal aid. So there are concerns, even from defendant bodies, that not just it may not be unfair, it may not be fair on claimants, because of the new CFA damages-based agreements, but also that the cases simply won't get to court at all. Isn't that right?
So,
sorry, so that question was addressed to me. Was that specific to me or to the panel?
I'd welcome a view from the others as well.
We have seen when our members are dealing with claims, the fundamental issue is liability. In the great majority of claims, liability is relatively straightforward to establish, and quite a lot of the issues then are what actually has to be paid in terms of compensation. Our members are used to dealing with catastrophic claims. They deal with it all the time. We've seen no evidence to us that has demonstrated that this is going to affect people's ability to take forward cases, or that lawyers will be any more reluctant to take forward cases. If someone presented us with that sort of evidence, we'd be happy to look at it, but there's no evidence as far as we can see. When it comes to the lower value claims, they're now defying anyone not to know that they can make claims, because they're surrounded by people encouraging them to do so all the time. So we understand people might have concerns about access to justice. We've seen no evidence it's going to make it more difficult. On the contrary, we think we need a system which makes the whole system quicker, more efficient, cheaper, because we're all paying our premiums which fund these claims, and that would be the benefit of everyone. And a great deal of people have before the event insurance anyway, particularly for motor claims, which they can then use under those circumstances.
Catherine Hopkins.
The key difference, I think, has been illustrated by Mr. Starling when he says that liability is not a difficult thing. That's quite the opposite in clinical negligence. If someone is run over on the crossing across there, everyone here will be able to tell whether or not that person was injured by a car and whether the car was being driven negligently. That is not the case in medical negligence. When people go into hospital, they've got something, apart from a pregnant woman who's going in to deliver a baby, they have something wrong with them. So if they come out still with something wrong with them, that may not be a cause, the cause may not be negligent. It could be something else, and that means that a lot of work has to be done on liability and causation. It isn't straightforward and cheap to investigate clinical negligence claims. The other thing I'd say is that practically no claims are worth less than £10,000 or less. If they are, they're not really brought. I mean, under legal aid requirements, the cost-benefit requirements, you would not get a certificate for a client with such a low-value claim. Occasionally there are difficulties along the way and the damages are lower, but initially your initial valuation must be much greater. So we are, in a sense, talking about different issues here. We're talking about the biggest claims with the most complicated issues on causation and liability, mostly causation. And they're currently virtually all legally aided. So while it's such a glib thing to say, oh, well, they can all be CFA'd, you would be asking firms like Stewart's, who already do a large amount of conditional fee agreement, suddenly to take a chunk of the biggest, most complicated cases into their conditional fee agreement management system, which will mean funding up to £100,000 worth of disbursements. I know there's a concession on the insurance, but you're actually talking about firms carrying an overdraft for those disbursements. We don't have a remit for lawyers, but we do recognise that lawyers have got to remain in business in order to provide access to justice to our clients who are former patients. And we worry a lot about this. Many of our members say they will not be able to afford to take catastrophic injury cases on conditional fee agreements. My phone rang all morning on the 21st of June when the bill was published with people I know who are our panel members who work at relatively small local firms, particularly in the north. And I think the north will be more affected. Muris's firm is a largish firm and it has a Leeds office. It's fairly unusual for the larger firms. There's one other. They ring saying, well, we do CFAs. We do CFAs for the slightly lower value cases. We do all our catastrophic injury clin neg cases on legal aid, and I don't think my partners will accept that extra burden on the firm of 3-4 years of building up work in progress being unable to bill it. It's going to be a significant problem, access to justice. I talked earlier about the problem if the case runs and is successful, but I think actually finding a solicitor who can say to a young mother with a child with brain injury, yes, I'll take your case on from today on a conditional fee agreement, is going to be like hen's teeth in some areas. And in others, they will say, yes, if you can deposit £3,000 with me to cover the cost of the initial investigation, I'll do that. You might risk losing that money. But when I've got the initial reports from, say, an obstetrician and a paediatrician minimum, I will tell you whether my firm will take it on a conditional fee agreement. I think that's a problem. So.
Dave Watts, Ben Wallace, Alex Cunningham, Tom Brake.
Isn't the problem with medical negligence a problem that we're looking at a wide span of different conditions and different issues that could be addressed? You've just talked about, for example, a child that was severely brain damaged. If the case would be taken to be a lot of upfront costs that would have to be incurred before the solicitor would know if there was a case or not. I think we were referring to some of the minor cases which you think there isn't a problem in. If we've heard from previous witnesses that CFAs would probably not be available, and you just repeated that just now, is there then likely going to be a growth in insurance policies? Would your members see a growth in people wanting to take out an insurance policy against that if they were going into hospital? And what would the cost be for someone who wanted to do that?
I would have thought that was unlikely. It's not something I've thought about. I do agree that to some extent we're talking about very different situations. As I said, our members do deal with catastrophic injuries. They're not really around the problems we're trying to address by the Jackson reforms. They are, by definition, they have to be dealt with over a long period of time. They cost a lot of money. The legal fees are much more proportionate to the amount awarded, and I think that's a slightly separate issue for our members. The big issue for our members is the huge amount of low-cost bodily injury claims. For example, the £2 billion worth of cost of whiplash claims, by far the greatest in Europe. I don't know the extent to which there are low-cost clinical claims, but we're all familiar with the sort of advertisements we see in hospitals inciting people to make them. And our issues really are with the lower value claims where the costs are quite simply too high. People are encouraged to come forward. I think the words of Lord Young was that there's incitement to litigate and come forward, and that leads to large numbers of exaggerated or certainly fraudulent claims in some areas. And that's where we think these reforms are going to be instrumental in getting these costs down and getting these sort of claims down, so that the genuine claims, and I come back to my original point, the genuine claims where people have been injured or they are ill and it's not their fault are dealt with quickly and people get proper and speedy and correct redress.
Ben Wallace.
Thank you. Can I just ask for all three, the question about liability that Mr. Starling referred to. Do you think the claimant and a claimant's lawyers have some liability towards the claims they make? That the success or failure of their claims, they should carry some liability for them?
Nearest Lyons.
In terms of if the claims are successful or unsuccessful.
Yes. Costs of the case, or
well, the key point with all litigation is who has responsibility for it. And as a report by 3 leading cost judges pointed out very recently, they said that the main cost should be put at the door of defendants who drag cases out, deny liability unnecessarily, and then try to settle at the end, very close to the court door, and then complain about being penalised in costs because they've chosen to conduct litigation that way.
But they've had a cheat to defend themselves. You mean
they're entitled to defend themselves if they've got a defence. But if they say no liability and then 2 years later say, OK, we are liable, they play a numbers game. It's an attritional strategy that works very well when you take a global look at the numbers. The difficulty for claimants, of course, we've got to do our best for our clients. Nothing pleases me more than when a defendant admits liability early on, because I know then those expensive issues are resolved at an early stage, and we can get on to sorting out what this client needs to help improve his life, improve his independence, improve his quality of life. Those are the key things that the debate ought to be about, whether the levels of damages are enough to do that. Now, the Law Commission reported 10 years ago that damages were too low then and recommended an increase of 50%. That's never been introduced. And we're talking now about taking 25% off current levels of damages to fund these reforms. Claimants will pay 25% of their legal costs to at least subsidise the person who injured them in the first place.
Could I hear from Catherine Hopkins about the same issue about liability?
Well, I think that
Catherine Hopkins.
I beg your pardon, sorry. I think that already lawyers do incur a liability in terms of costs, because if you take a case on on a conditional fee agreement, you risk being paid nothing. So there is already that. If you take a case on legal aid and you fail, the costs paid to a solicitor on legal aid are considerably less than the inter partes costs, so there is a smaller but still a risk there, and also probably a much greater risk if a solicitor is a bad judge of risk and takes on lots of cases on legal aid that all fail, or even if they fail at the first hurdle, which is the initial investigation, they risk losing their legal aid franchise. So I don't think it's without risk already.
But some of those risks will be mirrored in the defendant. I mean, the defendant will go through the process saying, well, if I defend this, it's going to cost me money just to go out in the process, to start the process. And I think, while you talk about some of the severe clinical negligence cases, clinical negligence is 5% of the total market of litigation.
It is, but it's all
but it's a tiny, it's 95% is not clinical negligence. And we talk about personal injuries, and Mr. Lyons used examples of industrial disease, but all the sort of falling down in cracks and the minor industrial injuries you sort of left out, which is a whole, where there's blame, there's a claim, the ambulance chasing stuff is all out there, driving up costs. It is a very large part of the civil claimant market out there that's impacting on my constituents' insurance policies, my constituents' businesses. And one of the reasons they get hammered is through the success fee. And this is why I wanted to ask about liability and come into it. Rupert Jackson refers
Can we have a question, Mr.
Yeah, this we're going to get at. Rupert Jackson refers to the success fee. Now, the success fee is a win bonus. One of your members, Mr. Lyons, had on his website, he described it as a win bonus for solicitors, for winning a case. But the defendant, who may have no liability in other cases, has to pay to compensate that lawyer for having unsuccessful cases elsewhere. I mean, do you think that is a fair principle to a defendant, that he or she has to compensate a lawyer for cases that are not linked to that defendant? Why should they? What have they done wrong to have to pay for your claims elsewhere that may be bogus, may be unsuccessful, or may be claim farmed? And I'd be interested in your view on why we should continue a success fee.
Quick answers and then we'll move on.
Thanks. As quick as I can. They don't have to pay for bogus or fraudulent claims. They're only paying those premiums in cases which they've lost, where they've insured somebody who has been found to be liable or negligent. And it's a simple premise. It's the insurance premise of the many paying for the few. The idea behind it is that the success fee on the winning cases allows firms like mine to take cases that are unsuccessful. And success fees were calculated when they were first brought in to be revenue neutral. The idea is that across a basket of cases, lawyers don't make extra money, they just make enough to cover the losses.
That's not the case.
No, Mr. Wallace, I'm not going to carry this on. Nick Starling, anything to say?
I'll very quickly say that I think one of the problems we've got is that it's all of us playing for the many rather than just the many playing for the few at the moment. And that's one of the problems we've got here. I emphasise we're not talking about the very high-end difficult cases that Ms Hopkins has talked about. We've got a dysfunctional system. In a dysfunctional system, people play in dysfunctional ways, and I think that we need a system which makes sure that when liability is there, it can be dealt with very quickly. If people play the system, if they take unmeritorious cases forward, or if defendants spin things out, then there should be ways of penalising them for doing so. We need everything that encourages the system to work smoothly and effectively and quickly, and I think that it's that dysfunctionality that Jackson tackled and we need to strip out of the system.
Thank you. Alex Cunningham, Tom Brake, Damien Hines, Andy Slaughter.
Lots of people agree the compensation culture is getting a little bit out of hand, and you talk about it being dysfunctional, but surely insurance companies appear to be quite keen to encourage their clients to seek damages, inquiring very kindly after them and then making sure and checking for accidents. Now, I don't know whether that's a policy to try and see off the no-win, no-fee people or not, but I mean, it strikes me that perhaps the question really is their proactive approach not as much to do with growing the compensation culture as the no-win fee merchants who spend a fortune chasing ambulances?
Well, if I could just take that very quickly. First of all, the government's own report by Lord Young last year said there was no compensation culture, so that's Lord Young saying that. And secondly, in terms of the increasing claims, of course, broadly speaking, employer liability, public liability, the numbers of claims are falling. It's only in RTA and recently in clinical negligence that claims are starting to go up. Whether that is down to third-party capture or assistance by insurers, their payment of referral fees, those sorts of issues is an entirely different matter, and it's not really an issue that's actually part of this bill, which, for my part, is about whether clients who've got legitimate claims are able to get access to justice and whether it's fair for them to pay up to a quarter of their damages in legal costs.
Tom Brake.
Sorry, can I?
Yes.
I beg your pardon. All the questions put partly to me, so may I answer that to the point? Well, there is a compensation culture. It may not be absolutely widespread throughout the UK, but there are parts of the United Kingdom where if I go to the back of your car, you are 3 times more likely to make a personal injury claim than other parts of the United Kingdom. There are parts where there's an expectation that you can make a claim, and we need to sort that out. What insurers want to do, if I come back to the analogy, I don't tend to do so, but if I were to run into the back of your car is out of action, needs repaired, you need a replacement vehicle, you might have an injury. It's really important that you are helped, and you are helped quickly, and that's what you should expect. I'm liable, you should be helped, and you want people to come to you. And it may well be that my insurer will come to you direct and say, can we sort you out? That's what's called third-party assistance. Now, we're all familiar with this issue of referral fees. Referral fees are a symptom of the way the system has gone wrong. Everyone's at it. Insurance companies pay referral fees, so do the firm that comes and picks up your vehicle might pay a referral fee, the garage might pay a referral fee. Jack Straw has alleged that the police and the NHS pay referral fees. Everyone's at it. It's not part of this bill at the moment, but it's vital to ban them. But we also need to cut off the fuel supply to them, which is the excessive cost of the system. There's a simple bit of arithmetic here. You can charge £1,200 for a simple road traffic accident cost. You can pay £800 for the referral fee to get that £1,200. So you make £400 for a very relatively straightforward claim. Let's get rid of the referral fee. That's £800, and you can reduce the costs. If they were £400, everyone would be happy.
And we'll get lower insurance premiums as a result of it.
If you can tackle some of these big issues, I mean, if you can tackle the £2 billion cost of whiplash claims, there's 1 in 140 people in this country make a whiplash claim every year. I do not believe that people in this country have the weakest necks in Europe. It's simply inconceivable.
We have a fixed cost regime in place for a year, and my insurance premium hasn't come down.
And insurers last year motor insurers last year made an overall loss of £2 billion. There's a bit of simple arithmetic you can work out there. But that's what's pushing premiums up. It's a very competitive industry. If we can strip out these unnecessary costs, if we can sort out the problem of whiplash, if we can deal with these, the claims management companies that are inciting people to make claims, then insurers compete with each other and premiums will come down.
Can I just say there is no compensation culture in clinical negligence. Not only does Lord Young say that in his report, so does the NHSLA. And also, if you look at the number of adverse incidents reported in the NHS compared to the number of claims issued, the proportion is something. I haven't got the figures, and I can provide you with those figures, Chairman, but it is enormous. It's less than 1%. Thank you.
Tom Brake.
Mr. Starling, could I just ask you? I think you've answered the question. So your view is that an appropriate fee for an RTA would be of the order of £400 or £500. Is that what you're saying?
I wasn't making a formal suggestion. I was just the chair. I was just saying there's a simple piece of arithmetic that it's worth people's while to pay £800 or so as a referral fee to get a £1,200 fee for an RTA. And I'm just saying you can do a simple bit of arithmetic that works out what a more appropriate fee might be. I know that for example, in Germany, a very similar sort of situation. I think the fee is around about €300 or €400. Certainly much higher in the UK than others. I'm not here to dictate what that fee should be. I'm just saying there's scope for it to be much lower. And that's a simple as success. The portal's been a huge success. It has sped up the claims under £10,000. Sometimes they've been dealt with in hours rather than days or weeks. And I think that the amount of input that's needed doesn't need that sort of fee to sustain it. And if lawyers are not having to pay the referral fee to get the business, then they still should be able to make a decent living out of it.
Thank you.
Damien Hines.
Thank you, Chairman. I'd remind everyone that not everything that Lord Young said was greeted with universal approval, but this point about there not being a compensation culture, I mean, excluding the relatively small amount of complex medical negligence claims, if you watch daytime television, it's very difficult to come to the conclusion that you and as you say, Lord Young have. Do we know? Not that I do. Do we know what the size of the advertising and marketing market is in this regard?
I think it'd be interesting to see. It would be interesting to see whether there's a correlation between the advertising and the number of successful clinical negligence claims. I would say that it's probably likely that it results in more telephone calls to solicitors saying, I think I've got a claim, will you listen to my story? But for those firms that keep stats, they will tell you that they perhaps take 1 in 10 cases on, and that doesn't necessarily mean they'll succeed. They will take them on to investigate. Most people, and I was in private practice as a clinical negligence solicitor for more than 10 years, most calls you listen politely and say, sorry, there isn't a case that we could take on here. So there may be a perception, but actually the cases don't proceed.
I suggested that if it wasn't a profit maximising activity, that people wouldn't be spending the money on the advert. So whatever the calls into cases taken on ratio is, I'm not sure. Well, I'm sure it's relevant, but it doesn't. I think it doesn't change the argument. There must be greater prevalence of these things in order to justify all this spend.
Lord Young in his report recognised that, with the prevailing advertising, there was a perception of a compensation culture. But the point is that the figures, broadly speaking, show that claims are falling, not going up. So that's important to recognise that. But from my perspective, if there are concerns about advertising, if there are concerns about referral fees, fine, address those directly. Taking a quarter of an injured, innocent claimant's damages is not the way to do it, nor is withdrawing legal aid from some of society's most vulnerable people.
Nick Starling.
You asked, I don't know what the advertising spend is. What we do know is a very strong correlation between the location and density of claims management companies in particular parts of the country and the consequent bodily injury claims, particularly minor bodily injury claims. And I do come back to our view is that there quite clearly is in some parts of the country and in particular areas of activity such as motor, there is a compensation culture, undoubtedly so. And we think that anything that can be done to strip out this propensity to claim, and I think Lord Young used the word incitement to litigate, is extremely important.
North Finsbridge for his first go, and then Andy Slaughter.
I don't accept that at all. Your claims are going down. You may say in your sector, but generally there is no compensation culture. And I speak as a lawyer myself. Going back to Mr. Hines' point, if there were a compensation culture, why would they need to advertise?
Our members, the number and cost of bodily injury.
Precisely, they know where to find a lawyer.
We have
Nick Starling.
We have a extremely good road safety record in this country. I think that last year road deaths were below 2,000 deaths a year, and that's a great improvement. But our members have not seen it because they see a constantly increasing number and cost of personal injury claims. And I come back to the fact that many of them are minor bodily injury claims, and we think it's a compensation culture. Just to finish that comment, I come back to the point that the catastrophic claims I'm not including in all this. We do deal with a lot of those. There's a very particular problem around catastrophic injuries with young drivers and their passengers, and I'm not including that in my remarks. I'm focusing on the lower value, the exaggerated, the fraudulent.
But the measures in the bill will impact most significantly on those types of cases. That's the real difficulty here.
Andy Slaughter.
You have made some quite sweeping statements. I'd like to put some of them back to you, if you don't mind. Advertising, well, the big advertisers are the insurance companies. One insurer alone spends over 180 million on advertising, including things like BT Insurance, which you would put as an alternative once you've got rid of 80 insurance. You imply, or you say that there's a compensation culture, there are too many claims, many of them are fraudulent. But aren't there almost 95% of people who do claim, they're either making a first or a second claim? You don't have a large incidence of serial claims. And you also say, as I understand, you also say insurers aren't making profits. Well, some are. AvMA is a big top 10, I think, insurer that's making very healthy profits. And I asked them why, and they said because we manage our business, we manage our claims very well. So aren't you possibly making excuses for inadequacies in your own industry? What it seems to me, and this is the main point I would like to put to you, what it seems to me is you're saying, well, if you've got a very straightforward claim where liability is clear, then you don't need a lawyer, insurance company will make an offer. Well, we've given examples given to us where the initial offer made by an insurance company is then beaten by, when the claimant gets a lawyer, 6 or 7-fold, which doesn't doesn't imply that the insurance companies are always being entirely even-handed, as you wouldn't expect them to be. So what happens in those cases where you have somebody's going to pay for meritorious but marginal cases? Should it be the claimant out of their damages if they succeed? Should it be the NHS who may have to pay for their healthcare costs or the Department of Wealth expenses? Or should it be the tortfeasors insurers at the end of the day? What do you think is fair in social terms?
I think what's absolutely fair is that insurers pay valid claims where there's clear liability and someone's been injured or made ill for it. It's not their own fault. I've made that clear right throughout. Our member companies compete fiercely. They advertise. I've noticed that other companies in other sectors advertise too, and that's generally accepted as a way to win business. And also, without commenting on the profitability of otherwise of some of our members, in any realm of business, some are more successful than others. That's just the way that business works. You say there's lots of examples where lawyers have got a substantially larger settlement. I can point to many examples where the original claim has gone down substantially. We can all argue on the fringes about particular cases. And as I said, in a dysfunctional system, people tend to behave in dysfunctional ways. If we can sort out the system, if we can streamline it...
Why is it less dysfunctional for the claimant
and his daughter?
Why is it less dysfunctional for the claimant to have to pay from their damages than for insurers to have to pay?
Well, because Jackson did a package and he compensated for that by increasing the general damages so that the whole thing works properly. He accepted that there were changes. The way that general damages increases, which I don't believe is in this bill, it's elsewhere, is important. And we have always said, the insurance industry has always said you need to take Jackson as a package. We've not tried to cherry pick the bits we like. It would be very easy for us to have said, we like the cost shifting and so forth, but we don't like the general increase in damage. We said you need the whole package as a whole to come in.
I appreciate
and some of that's in this bill and some of it's outside.
Would you therefore appreciate the retention of legal aid for clinical negligence, which is what Jackson says?
Our members don't deal with legal aid issues, so I can't comment on that. I can comment on the fact that a lot of people have before the event insurance, and we're keen to encourage the better take-up, better awareness and understanding that people can use before the event insurance. So, of course, that relates to motor insurance in particular. 2
minutes to go. Catherine Hopkins is itching to come in.
Sorry, I was, and now I've suddenly lost my train of thought.
May I make a quick observation while Catherine recovers her train of thought? The 10% increase in damages was Sir Rupert's suggestion to offset the losses that would be incurred. It's based on a flawed piece of analysis by Fenn, who uplifted 10% of all damages, not just the general damages, and that isn't what the proposal is. The proposal isn't in the bill, but the impact assessment that's published with it makes the same mistake. Based on a set of data from a defendant's cost consultants, Jaggards, it uplifts 10% on all damages, not just general damages. And that isn't the proposal, even though the proposal isn't in the bill and we are told it will come elsewhere. It's also, in my view as a practitioner, an unworkable proposal. And the concern is that when you negotiate with defendants, you ring up and you say, right, this claim is worth £2,500. They say, no, it's worth £2,000. We say, OK, we'll do a deal at £2,250. I then say, can I have my 10% uplift on general damages? They will say, you've got it already. We're never going to see the 10% uplift in practice.
30 seconds to go. Catherine Hopkins.
I was just going to say that we believe that the tortfeasor should pay, in answer to Mr Sauter's question. And if the tortfeasor is insured, he's prudently provided for this eventuality. The NHS is obviously self-insured in a way through the CNST, and that hasn't been raised so far today, but I would just like to raise a concern that I see no impact assessment on the NHS in the cumulative impact assessment to the bill, and it hasn't been raised today, but we would question how much extra it will cost the NHS.
Order. Could I thank our witnesses for coming before us today? Before everyone leaves, I now call the whip to move that further consideration of the bill be now adjourned.
I beg to move that further consideration of the bill be now adjourned.
The question before the committee is that further consideration of the bill be now adjourned. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The committee will meet again at 9 o'clock on Tuesday morning. Order, order.